purpose of these agencies is to protect against those who are absolutely violating the law. Hence, these agencies have the ability to immediately stop and desist you from what you're doing. But in order to come back and impose all these fines and destroy you and ruin you and pass judgments, and the other thing is, Greg, like all these press releases, right? Like they're just not fair.
If you're bringing an allegation that has a component of fraud, which all FTC cases that are brought have a component of fraud, it's a false or deceptive or misleading action, right? Which is a fraud component. If you're bringing that, it cannot be through an administrative action. It has to go through court if you're trying to get monetary damages.
Welcome back to the Don't Say That podcast episode. And Greg didn't let me have fun myself for too long. He's back, and he's in a nice, shiny suit today. Is it a court day today, Greg?
It is. I have court this afternoon.
Never dresses up in a nice suit and tie for me, but for the judges, he does. I get that. Listen, we're going to talk about another case. The Chevron episode was a pretty big hit, and was very interesting to kind of get the take on how that was. Today, we're going to talk about an SEC case. It's not the FTC, but there's a lot of three-letter agencies, and when the Supreme Court or when there's other cases, they rule on these, it kind of trickles down its impact on the other three-letter agencies. And we're going to talk about this particular case because it also is very relevant to some of the ways that the FTC and other similar organizations are enforcing the law. So we're going to talk about that, and then if any other questions come up during that time, we'll talk about that. But remember, before I continue, all right, this book right here, how did I not have it set up? Bam. Don'tSayThat.com. Even Greg's got one. He's reaching for it. Don't say that. He's got it buried all the way down somewhere. Man, Greg, that is what you should be proud of, not those stupid encyclopedia thingies that you've got behind you with the book in front. What are those? Is that the law? What are those books behind you?
Yeah, these are really cool books on it. So that's the law. So they're called reporters, and that's where all the cases are. So when I was in law school, they'd have a big law library, and you can get it all online. But these are all the cases are put into a books. These books behind me, I had this because I have an office in Kansas City, Missouri, and this attorney was retiring, and he had these old law books where some of them are 100 years old, and so he just gave them to me, and so I love it. And so I can pull cases out of it. I mean, it's not efficient, but it's fun. That's what they are.
Chat GPT. Probably that's all those cases.
In 1920, there wasn't Chat GPT. There was internet. There was books, and you have to read through everything to find cases. Where now you've got Westlaw and LexisNexis.
You know, it's so crazy because I remember in elementary school the encyclopedia, and using it, like actually using an encyclopedia for like papers and research and things I'm doing in school. And I remember when the internet came out, we had AOL and Yahoo and. Like I don't even know if you can buy encyclopedias anymore. But anyway, so we go off topic here, guys. Let's get into it. So Greg, give us a briefing. There was a recent case about 2 weeks ago. We haven't had a chance to talk about it yet. SEC versus, you said Driston?
Jarksey.
Jarksey. I don't know where that guy came up with Driston.
K-E-S-Y. Jarksey.
All right. So what's the story, and what was the ruling, and how does it impact the rest of us marketers?
So this is an SEC case. So the Securities and Exchange Commission brought an administrative action against Jarksey. And just so you guys all know, there are two different ways that actions are brought by regulatory bodies. One is they'll actually file an action in court, and they'll pursue that through court, or they'll bring an administrative action where they actually have their own internal judges and procedures to handle things. And it's not just at a federal level, but several states have it as well. The state of Utah has an administrative process that if you go afoul of the Consumer Protection Division, they'll file an administrative action against you, and they can go through that process through that. Now, what makes an administrative action super hard, and oftentimes you'll hear the term kangaroo court, is because instead of going in front of a neutral arbitrary judge, although I will say this, when you have a state or a federal government bring an action with state or federal attorneys in front of a state and federal judge, I mean, you're behind the eight ball already, right? Because the perception is the government is already right. But with the Looper case that we talked about a week ago about the overturning the Chevron rule, and now here with this Jarkesy case with the SEC, understand the Supreme Court is recognizing the overextension of the federal regulatory bodies in enforcing regulatory actions against companies. They did it in 2021 when they had the AMG capital management case. And now this court is consistently saying, whoa, government, you're taking too many liberties and civil liberties away from businesses and individuals. So in this Jarkesy case, what they did is they brought this administrative action against this company for violations of the Securities and Exchange Commission Act. And in doing so, they found that this company had violated the law, and they implemented a huge monetary judgment against the company. Now, again, assuming that you went into a federal or state court, that there would be some sort of arbitrary judge that was going to hear the case and listen to the merits of the case and rule and not have any sort of biases against the company. In this case, it didn't happen like that. It came before the administrative body that was under the Securities and Exchange Commission, people that were, administrative law judges that are employed by the commission, and they implemented this huge judgment against Jarkesy for violations of the SEC Act. So here's the case now. So Jarkesy appeals because he says this isn't fair. This is a kangaroo court. I never had a chance. I never had due process of law to have the ability to defend against this action because it's their processes, it's their judges, it's their commission bringing this. There has to be separation between an administrative process to award millions of dollars in damages for companies to be able to have a fair chance to fight against these. And so they appealed to the circuit court, which they lost, and then it goes to the U.S. Supreme Court. And the U.S. Supreme Court looked at this, and on the 27th of June of last month, so just a few weeks ago, they issued a ruling in favor of Jarkesy, saying that there has to be separation between regulatory agencies and the process in which they are awarding monetary damages against companies. It can't be an administrative process that they bring at a commission level like the SEC, have their judges, have their mechanisms, and then award millions of dollars against companies. Instead, from going forward, these actions need to be brought in federal court where there's at least pretext of having somebody that's unbiased to review and allow the company to have defenses against the commission. And we know with cases like with the FTC, like the DirecTV case, they do lose. So sometimes they'll go into court and the federal courts will rule against them. So the takeaway from Jarkesy is this. If there's going to be an attempt by a regulatory agency like the SEC, they have to bring that action in court. They can't just go get a monetary damages through their processes. Now, how does that apply to us? Because I know a lot of times we don't talk about the SEC, although there are a lot of you that have FinEd products that talk about investments and everything else like that. And so you have FINRA and the SEC that you're concerned about. How does that apply to us? What applies to us like this? So we can take the extension of Jarkesy to the Federal Trade Commission. The Federal Trade Commission has the same administrative process, a similar administrative process as the SEC. And they can bring an administrative action against companies, and they then can go through that process itself. So currently they have several administrative processes, or they have several administrative cases that they're taking internally right now. Same process. So if you remember some of our prior episodes when we talked about these notice of violation letters that they've been sending out since October of 2021, that stems from an administration, group of cases they brought in the late 70s and 80s. They used to use that process clear back then, not in the courts, but in administrative. So in my mind's eye, because the FTC hasn't done this yet, they haven't gone into court on those notices yet in any cases, even though they issued them over 2 years ago. My guess is that they were thinking that they would try to bring this through an administrative action like they did in the 70s and 80s. But with this ruling now with Jarkesy, I don't believe they can do it to get the monetary fines that they want. And in fact, I don't believe they can do it. They cannot do it. So this is a huge blow. This is them coming in and saying, the Supreme Court saying, regulatory agencies like the Federal Trade Commission are going to be barred from bringing administrative actions against companies and get huge monetary fines. If they want to get those fines, they have to go into court, which at least on, at least on a facial look, gives the business an opportunity to defend it. And with AMG Capital Management, unless you're engaged in telemarketing activity or you're violating the Business Opportunity Act, the federal BizOp statute, then they shouldn't be able to get an asset freeze against you either. So that gives you a better fighting chance than you had before. And so if you look at it, what's happening is U.S. Supreme Court is just slowly taking regulatory authority and it's just taking it one step at a time.
So, I find this really interesting because as you're talking, I keep thinking about my case and how it would have impacted the defense in my case. And my perspective, and this is my personal opinion, not a hit or knock on any agency, but, I think it's fair for me to say that, at least in my case, I thought it was way overreach. I thought the way I was treated and I thought, the way things went down, I didn't think it was fair, but it is what it is. I'm not just saying I thought there was a better way. In my opinion, when I look at an organization like the SEC or FTC, and when I look at the level of the quote unquote infraction as they see it, I think there is some form of responsibility on their heads to do an adequate, thorough warning before you just go pilgrimaging through the entire company. And I just never got that. And in many cases, not in all, in my case, had I gotten a proper specific warning that told me, hey, we don't like what you're doing, they would have seen an absolute immediate shift. I just never got that. And I think right now, to me, it almost feels like piece by piece, case by case, the Supreme Court's almost in a way agreeing with me, where they're saying that the purpose of these agencies is to protect against those who are absolutely violating the law. Hence, these agencies have the ability to immediately stop and desist you from what you're doing. But in order to come back and impose all these fines and destroy you and ruin you and pass judgments and the other thing is, Greg, all these press releases, right? They're just not fair. I mean, to do a press release, to literally say I was found for doing the following thing, by who? I didn't agree to it. I settled. I still disagree with their perspective on my case, respectfully so. But they've set it out there like it's a final statement, like it was found in court to be that way. It's just not, it's kind of dirty. If this happened in an individual to an individual case, there would be like you can't do that. And I think that's what we're seeing from the Supreme Court. And I agree with it, not only from the perspective of, obviously, I agree with it because I've been through the case and it sucked, but generally I feel like that's the purpose of these organizations and that they can stop something immediately. I think they all should be able to do that. But in this case, Greg, let's go back to my case. So in my case, and if at any point I'm sharing too much or something as my lawyer you feel like I shouldn't say, please let me know and then we'll delete it. But in my case, they made a big stink about that notice of penalty letter, right? Which I never got. But they say I got it. And so let's for a minute assume I had received it. Okay? I'm going to play assumption here. I went later on and read the letter as they brought it up later in the case. It literally said nothing. Actually, at the beginning in bold letters at the top, it says just receiving this letter does not mean you've done anything wrong. It's an FYI, which is not a warning in my opinion. I think a warning is, hey, you're doing following XYZ things wrong. And if you keep it up, we're going to get you. That wasn't there, okay? So I'm sure even if they had said that about me and I had not seen it, because I didn't get it, I'm sure people would have messaged me and said, hey, by the way, there's this notice about you should read it. So in my case, they came out, and it's in my complaint letter. They make it sound like, hey, we specifically, adequately warned him. He didn't listen. He kept doing it. I mean, it makes me sound stupid, makes me sound evil, and I never got the damn thing. And even if I did read it, it wasn't specific. It wasn't really thorough at all, in my opinion. And so my question to you is, if at that time if this case happened today, if I got that notice today, or not the notice, but if they sent me a CID today, As a lawyer, would you step up and just be like, hey, that notice of penalty is defunct due to this case? Don't even bring it up with me anymore. Like, how strongly or would they come back and say, that's SEC, not FTC? Shut up. We can still do it.
No, I definitely think the FTC saw this ruling in the U.S. Supreme Court, and especially after Looper, they look at both of those cases because Looper is EPA, right? It has nothing to do with FTC either, but the rulings in both those cases substantially struck down the authority of other regulatory bodies such as the Federal Trade Commission.
So do you think they're not going to even do the notice of penalty anymore? Do you think they're going to pivot again to find some different way?
I mean, if you look at the Automators LLC case that was settled, and then there was a case that was settled last week that was another $7 million settlement case. And they mentioned the notice of violation in that case as well. I'll remember the case name in a second, but they're still mentioning it. So I don't know. I don't know what they're going to do on this. I just think that if I were representing on a case and that came into me, I'd be like, look at this Jarksey case. I mean, if you look at this and what, I just don't know how you're going to bring this in court. And until they do bring it in court and they're successful in front of a court, I'm not going to give it a lot of.
So we made that argument even with our case, right? We wrote a nice 2-3 page letter back and we said, hey, your points and your things are defunct due to these cases. But those cases were, I believe, if I remember, not related to the FTC directly. They were like SEC. And if I don't remember.
You're messing two different arguments. No, the letter sent back to the commission had to do with the only time that a similar process had ever been used was in an administrative context, not in the courts. So that falls in line with what I'm arguing here with now with Jarksey. Is it saying if you're bringing an allegation that has a component of fraud, which all FTC cases that are brought have a component of fraud, it's a false or deceptive or misleading action, right? Which is a fraud component. If you're bringing that, it cannot be through an administrative action. It has to go through court if you're trying to get monetary damages. Now, this is an SEC case, but everybody I've talked to says this is going to apply across the board in regulatory matters. You add on to what Looper did, and then, the adding on for getting rid of the Chevron rule, it now says, hey, look, we're significantly going to hold back what, these rules and guidelines in which these regulatory bodies have enacted internally, and say to the judges, you do not have to consider these rules and guidelines as a direction, a guiding light for you to make your determination in court. You have full discretion to look at the facts and circumstances of the case, independent of those rules and guidelines, and determine whether they violated the underlying act, whether it's the Federal Trade Commission Act or the EPA or the SEC Act or whatever it is. So these two, within a week, severe blows to regulatory processes. And let's be honest, guys. Let me say this first and foremost. Truthful and accurate advertising is my mantra. I want, if you scammed my 86-year-old mom before she died this year, I would lose my ever freaking mind at you. Yep. I'm not saying that. I'm not saying go out and engage into certain behavior that's going to mislead your clients. But on the reverse side is laissez-faire economics, man. Non-government intervention. Let the market dictate supply and demand. If you're offering a product and service and people are wanting that supply and it's truthfully advertised to them, let them buy it. And let's not let the regulatory bodies come in and flex their muscles and try to dictate the process in which we try to defend ourselves and put us behind the 8 ball where it's always against us. Let's let companies be companies, right?
Let's free market.
Yeah, free market.
I'm a free market. In my personal defense, which really, I don't know. I guess it made an impact during my case. I'm sure it did at some level, but I didn't feel like it made an impact. I've been doing this for 21 years. Well, at that time it was like 19 years, 18 years. No one survives in a space like this by scamming people for 18 years, having a great reputation, an A rating at the BBB, and having no cases before, no legal cases, nothing brought to me by any consumer, no settlements, nada, nothing, no chargeback issues, the same exact merchant processors. And I felt like that should have been enough of a statement to say, hey, I think you got the wrong guy. Let's have a conversation. I'll change what you don't like, but I'm not the person that you're out here to make me sound like I am. Just a free market dictates that. Greg, I haven't even had a chance to share this with you, but I think you'll find this somewhat amusing. And I don't know if you've ever seen this with a client of yours before, but let's talk about this. So I actually want to talk, I don't know, but if everyone knows this, but I choose my words wisely so I don't sound vindictive, but there was another press release issued by the FTC about me, or about Learn, recently, the last couple weeks ago. This one hit. This one made me upset. It really did. I didn't talk about this with you. I took a day or two to really sidestep, because it just felt like you take someone who's it's like if you're defending yourself and like the person's like lying on the floor and completely helpless at this point, they're definitely not attacking you, but you just go and again just for like the pure joy of it. That's what this last press release from them felt like. It just felt completely unnecessary. But something really cool came of it that was humbling for me. But before we do that, before I talk about, so if everyone's wondering what I'm talking about, there was an extra press release. I do believe this is the final one. Greg, is this it? Am I done now with their press releases about me? Like, is there anything else coming?
Should be done. So you're talking about, and unfortunately, guys, what happens? It's like the gift that keeps on giving. Christmas vacation type stuff. Like, hey, Clark is a kid. It's the Jelly of the Month Club, you know? The
Yeah.
problem with this is you settle a case, they come out with two press releases immediately once you settle a case. The first one is kind of a bland, just informational. The second one is they have attorneys and staff that think that they're poets and they like to get creative writing, and they try to tie in, some sort of illustration of being, you know, Robin Hood, or, trying to steal from the poor to feed the rich or something like that. And so they try to use these. So it's two press releases, one that's flowery, one that's pretty straightforward. But then months after they take your money, and then they actually give it to some of the consumers because they figure out like who is allowed what, they do another press release. And that's what Onyx is talking about, because that happened a couple of weeks ago for him. So they do a press release saying, hey, we're going to give the money back to all these people who were scammed again. And they say it just like that. These are the victims of this action, and we're giving their money back. But then again, they do their annual reports. And in the annual reports, they talk about all the people that they sued the prior year and all the money they got back from them. And so they issue a press release again. But after that, you're pretty safe. So Onyx passed all of that.
Am I past the annual report one too?
Yeah, because I sent it to you, remember? And you were in there.
So
hey, that's my money. Remember when you said that?
Yeah. Oh, yeah. So we'll come back. We'll talk about that and my reaction to it in a moment, because it's actually not come up, and people have been not talking about it on social media, but it happened a few weeks ago. So just to wrap up the SEC case, Greg, it sounds to me like piece by piece, the Supreme Court is agreeing with my innocent thought of how the process should go, my non-legal, non-informed mind that says, hey, I don't think you guys can just be judge, jury, executioner in one place and just make all these rules. You got to follow the law. You got to inform us if there's you got to give us a chance. And then, yeah, if you want to go after us, go through court and all that, which adds some resistance for them as well, because courts are long and lengthy and takes resources, and makes both parties a little bit more amicable to a resolution that's not so, let's light a fire under everything. Sounds like that's where they're going. Where do you think are there any other cases coming? Like, are there other ones to expect where the Supreme Court's going to rule that will impact these three-letter agencies? Do you know of any others that might be coming up?
Announce their new term, some of the cases in the new term that they're going to look at starting in October when they go back into session. Just last week, and I haven't looked at all. The ones I've looked at are like the state of Idaho, and other states are trying to figure out the constitutionality of like gender issues in sports. And so I haven't looked at all the cases yet, but I will in the next week to see what's pending. But there are three major things that we have to understand that we're going to look at over the next year. And I'll go through those three. Number one, we're going to understand with Jarkesy, the reason why the U.S. Supreme Court really denied it was an argument about constitutional rights of companies, right to a fair and accurate trial, right to a jury trial. That's kind of the basis is under the Seventh and Fourth and Third Amendments. So they were looking at, some of these constitutional arguments, and that's what the U.S. Supreme Court eventually held was that, Article 3 of the U.S. Constitution allows for right of, representation and fair trial, and then, Article 1 and 2 talking about delegating legislative power and presidential removal and all that. So those cases, and when it's talking about the Seventh Amendment and these articles is what they ruled on was constitutionality. So the three things that I'm going to look over the next year in cases across the United States. Number one, what are the challenges to the FTC involving similar arguments they did in Jarkesy? Because although that was an SEC case, let's see cases where people start arguing Jarkesy applying to the FTC, and we're going to see that, and we're going to see what those cases come down to. Number two is in Jarkesy, there were two concurring opinions by Gorsuch and Thomas, and they hinted that there's other constitutional problems that were with the Jarkesy case that weren't addressed because they were never raised by the attorneys in the case. So understand this, when you're making an appeal, these are all legal arguments, but the court cannot do, and I'm going to use a Latin term, sua sponte. They can't just by themselves go and point out all the defects. They're limited to whatever the defects are which have been raised by the attorneys. Thomas and Gorsuch implied in their concurring opinions in Jarkesy that there are more constitutional problems than just the ones raised by the attorneys, that if ever brought back up, they would also consider in other cases like something with the FTC. So we're going to see whether the due process rules of the Fifth Amendment and how that looks at it in Article 3 together about depriving people. So when I say that, if you're not constitutionalists, third article, due process in the Fifth Amendment is depriving individuals of life, liberty, and property. Okay. So the argument is that these administrative processes don't really give you a defense, and they take away from individuals and companies their life, liberty, and property. Okay. The third thing that we want to see is the looper. We want to see how this decision with looper is going to be applied in that Chevron rule into court. So in the next year, we're going to see a whole slew of cases, and we're going to see how that comes into play. Sorry, go ahead.
No, that's great. That's a great summary. So more to come, and more, let's see. So I also want to be very clear, to make my position on this very clear, guys. I want to say exactly what Greg said. I'm such an advocate now of the moral, ethical, compliant marketing. I actually love compliant marketing. I really appreciate the rules. To be honest with you, this is a really weird thing to say. I look back at some of the things that we were doing as a company, and I understand, and I get it. I never come out and say, hey, I was purely innocent. I never come out and say, hey, I wasn't making any mistakes. When I say what I say, I just don't think I don't think I deserved what I got. Right. So I think in my particular case, I say, God, the system, there needs to be a little change in the system to accommodate the gray that came in my case. And it could have been done a little bit differently. But I want to be very clear when I say like the FTC hit me or whatever. I don't say it any disrespectfully. There are places where I'm just like, I wish they didn't do that. I kind of roll my eyes and I'm like, it's just unnecessary. And that, again, I feel like is an opinion, and that I make that clear. So let's see where things continue to go. But it doesn't mean, none of this should mean that you should stop being compliant or feel, like that's our mission. Is still, the revolution is still the compliance revolution. It's the right thing to do. It's what you should do. And I'm out here doing it right now and making it work, guys. I mean, we are building compliant businesses. I just had a call yesterday with Greg where I had a specific thing I wanted to be able to say and do. And I called him and I said, hey, here's, how do I do this? And we came up with a solution within minutes that got me what I wanted as a marketer and was compliant and truthful and honest and disclosed. It was very full of disclosure. So it's all doable. With my case, just so you guys know what was interesting, and I have a question for you on this one, Greg. So the $2.5 million that I paid, the FTC about 2-3 weeks ago started issuing refunds. They sent out $2.4 million. not 2.5. So I guess the $100,000 was kept as a tip or something. I don't know where it went, but they specifically said 2.4 million. I'm sure maybe it was kept to pay their expenses. But Greg, I found something interesting is that random people just got checks in the mail that had absolutely zero complaints from me. Didn't care. So the FTC did decide a long time ago. They told us that they were only going to consider refunding those who had bought into a coaching program or, something that was like 10K or above, because that was what my case came down to. It was a $14 million or 16, I forget now, we had transacted on the phone. So it was really only going to be those customers. And so a bunch of people that are in my mastermind that actually I launched, which is weird, Greg, because I launched that mastermind after the FTC, like I had been notified by the FTC. So I don't know how things got mixed up, but just, is that normal? Like, I thought that they only work with the people that actually complain, that they give you a time to lodge complaints and then they judge the refunds based on those complaints. Or is it normal for them to just like take everybody and just send a portion of the refund to everybody?
It's normal for them to, because you remember the way they look at this is they figure that the people who complain are only the tip of the iceberg of consumers that have been harmed. They
Okay.
look at everybody whose purchase has been harmed. So they will proactively go out there and proportionally refund to everybody, regardless if they complain or
Okay.
not. Because
So,
you
so
only
that's what
have
happened.
complaints, right? I mean,
Yeah.
so if they just did that,
Um,
they could have refunded everybody who ever complained and then had a whole bunch of millions of dollars left over.
yeah. Well, and so that's why. So to me, it felt like, because I started getting so many messages from people, and if you look at the letter that was attached, uh, a summary of it, it's like it's a short paragraph. There's a check and then a paragraph. It basically says, "Hey, we learned to be scamming people, and you were one of them. So here's some money." And I was like, really, like these are customers that like or super. Like, you gotta like, go out of your way to like just keep clubbing that horse, and it's like this is anyway. So what's really interesting, and there was a press release, and again, we sent out the $2.4 million because Learn and Onic are effing and evil, and we're doing all of this, and I'm like, just like we settled. I come and go in peace. Leave me be, right? It's just like bam, 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 bam.
You
And
gotta,
I
you
know,
gotta, you gotta understand them though, right? This is their time to say, beat their chest and say, look, world, what we did for you. This is our justification. So they live for these press releases because that's why they do these cases, to get it out there. So I've got this court case today. I'm not going to tell you all about it, but it's a regulatory action. And I got a text last week from the clients that said 5 years ago today, we were sued by this regulatory agency. This case is still going. Went to trial. Trial finished in May of last year. Judge can't figure it out because I personally believe that the regulatory agency did a poor job in their litigation of the case. If they had done a better job, I think it would have made it easier for the judge to figure out whether there were damages or not. And we're fighting that they've just done a poor job, but we'll see. Ultimately, I may still lose on this. But the issue with this is that these things just get bogged down. And they want, company probably generated $20 million in its existence in 4 or 5 years. They want a judgment for $100 million, even though the company never took that from clients. And the justification to the court in their pleadings is we want such a large judgment against them to show to the world, this is what's going to happen to you if you violate our laws. We want to send a clear message. So the press releases and everything else for that, that's what they live for, so they can, one, justify their own existence, and two, to show and try to intimidate the rest of the world. Like, if you mess with us, this is what's going to happen. We're a big brother. We're Teddy Roosevelt. We carry a big stick. We speak silently, but we're going to beat you and club you to death with it if you violate our laws, which is
yeah,
stupid anyway, because if you said it, if they had reached out to me and said, Onik, we think you're violating the law, and if you continue to do this, we're going to sue you, you would have looked at it internally and you had a choice. You could have either said, screw it. I'm going to go to balls to the wall. I'm going to go and get this taken care of, and I'm going to go, do my business in the way I want to do it. Or you could have said, life's pretty good. I've done a really good job with business. I think I'm going to go and invest in real estate or, something else.
Yeah. Or I could have just fixed it. Just stop doing whatever
Or
that
even
patient.
better, you could have fixed it. You could have called me
Yeah.
up,
I
Greg, what do we do? And
I
we
was I was
just like you're doing now.
Because here's the thing, right, Greg? So you told me that, listen, before you even got that CID, they've been looking at you probably for a year. They were building your rap sheet. They were watching you. So I'm like, okay, they were already investing resources in me. So they knew that there are statements that are being made that they don't like. So just like, I'm 40 minutes drive, man. Like I'm a phone call away.
They're
I'm up the
never,
street.
just for everybody's information, they're never going to do that. They're never going to give you notice. They're never going to.
Yeah, but I'm just saying in this fantasy land that I can live in where, we are all sing kumbaya and do good for one another. You know, I think I would sit down with the people at the FTC, and if we could have an honest conversation off the record, I clearly don't think they think I was out like scamming and screwing and like, running a Ponzi scheme, because they would have come down different. They would have stopped me different. The case wouldn't have gone 18 months. And you and I both know of other cases where they did think that's what's happening and they moved much faster and behaved much differently. So clearly I wasn't like a threat to public safety. And it's like, let's give it a shot. I've been doing it for that long. Like, let me fix it. And then but it wasn't about that. It felt more personal. That's what it felt like, at least. And then, so getting that second press release that went out with the money being released, partly because I wasn't expecting it. It just came out of the blue. Like the other one is like you sign a deal, they're submitting it to the judge. Like you're kind of getting daily updates. You're like, all right, the press release could happen like any day now. You're like prepped and ready. The second one, man, it took the wind out of my sail for at least a day or two. It just felt like, okay, you feel like you've been beaten on, and it's just like, leave me alone now. Like, I have gone in peace. I've done my thing. Like, I've walked away. I'm trying to, help and do it the right way, but you just keep coming back. And so I don't really like that about it. It makes it feel so much more than it needs to be. But then again, I'm not here to tell them how to do their job. They do what they do, and do what you got to do. But it is nice to see that the Supreme Court's making some rules to at least level the playing field for fairness and encourage the warnings to be more prominent. I think that is a good thing for us as an industry.
Yeah. I mean, I here I will say this about the commission. I think the goal and objective of trying to make sure that there's anti-competition, like that there's fair competition, and that consumers are getting what they're buying what they are advertised to. I think those are all good goals. And I would say there is a good group of people that work for the commission that are really good attorneys that really want to do well to protect the consumer. Because the problem with most of you guys is you're good marketers and you're not there out to screw over your clients. But there's a good group of people, and Anik, you sent me several videos this week, right? And then I watched those. We just didn't talk about it yet. Like, they're just trying to deceive people. And it makes it hard because when the commission sees all these bad advertisers, and they have a case where somebody's really gone rogue, and that they have 70% of their customer support calls or complaints, that it makes it easy to lump everybody in the same bucket. That, hey, if you're engaged in this type of business, this money-making opportunity business, that you're trying to deceive people. And the problem with that is it's hard to stereotype, right? It's like to say that any type of demographic is evil or bad or good. It's like you have to find out for yourself a lot of times in your involvement with them. They don't have time for that type of investigation. When they get involved and they commit resources, it's a path. I don't know what the percentage is once they start investigating a company, but my guess is, well, I know for a fact what happens. They start investigating a company, and then they decide two paths. One, it's so egregious because the number of complaints they're getting, or the number of the advertisings that they're looking at are so bad that they're like, we have to bring a lawsuit tomorrow, and we have to get an injunction, which is the nuclear option, right? Or like in your case, hey, there's some things that we don't like, but going into court immediately, not sure we're going to get that injunction. And I don't know if we're going to prove this off the bat. Let's issue a CID instead. But I don't know of the number of companies that get investigated, that how often they back out, because they won't. So one of the things we always ask for in these litigation cases is their investigation files. And we ask, we never get it because the courts won't allow that. Because when there's an active investigation, they'll call that work product. That's a legal term that says it's ours. It's like their attorney-client privilege documents. That's not what that is. It's work product. But I'm just trying to convey to you the kind of the message. It's confidential privilege that they don't have to give it over. Because I would love to see the number of cases where they actually start the investigation, then back off, and they don't issue a CID or a lawsuit. We don't know that. We don't know if that's 100% of the time they start the investigation. They always do one of the two, or if it's 50% of the time. We don't know. My guess, my personal belief is once they start an investigation, it's one of the two. I bet it's almost 100% of the time once they start one of these in-depth investigations, it's either a CID or a lawsuit.
Got it. Well, look, guys, do it right, and you don't have to worry. I can tell you right now, I go to sleep every night knowing I'm not breaking the rules. As a matter of fact, I made some decisions alongside of Greg that were really tough. There were tough decisions to change things in my business or to get out of certain businesses because I thought that it added a little bit or was risky from a compliance perspective. And it's just better. I sleep better at night. So be compliant. All right. Don't get caught in the web, guys, because like I said, it's the gift that keeps on giving, and it ain't a gift you want. And I hope I got the last gift, and that we're done with. I don't want any more gifts from the federal government. But thank you, Greg, very much. It's been a powerful episode as always, everybody. Make sure you hit subscribe. Get your copy of Don't Say That. CompliantAcademy.com is officially open and taking on new people. Come join us if you want access to this beautiful guy here without paying ridiculous fees. Once a month, town halls, private, behind the scenes. If you want the certification, if you want the legal documents, the disclosures, the contracts that help layer in protection, all of that, go join Compliant Academy. And of course, if you want the automated tools to help you get some analysis done on your copy to make sure you're being compliant, it doesn't replace a lawyer, but it sure as hell can help reduce the fees. Go to complyly.com. We're building a really amazing AI-powered tech to help you go compliant. All right, check it all out. This is On It. Greg, thank you very much. And as I always say, everybody, when life pushes you, stand straight, smile, and push it the heck back. Talk to you soon. Bye.